this video, I want to discuss a recent case there, December 2019 case involving a medical doctor who brought a claim to the Workplace Relations Commission. One of the principal things, or the substantive issue that had to be addressed by the adjudication officer, was whether the medical practitioner, the doctor, was in fact an employee or an independent contractor. This is a critical decision to be made by the adjudication officer, because if he was not an employee, then any claims that he might have under the Terms of Employment Information Act 1994, which was his claim, or any other piece of legislation which seeks to protect employees, would fall by the wayside, because you simply wouldn't get over the very first hurdle that he be an employee. The respondent in this case was a medical training provider, and the doctor provided or worked for the medical training provider and had a contract to do so. Now, that contract stated that he was an independent contractor and was not an employee. However, just because a contract says that an employee is an independent contractor doesn't necessarily make it so. In other words, all of the circumstances surrounding the relationship between the worker and the other party will be looked at to decide whether in fact the claimant in this situation, and the claimant indeed in any situation, is an employee or not. But the contract itself, the written contract, isn't necessarily determinative or the final word on the situation. The adjudication officer had to look at all of the circumstances, and one of the big claims, big defences of the respondent, was the fact that this medical doctor had his own practice, his own GP practice or some sort of a medical practice, and in addition was being paid a locum fee by the medical training provider, the respondent. And on that basis, the respondent was claiming that he wasn't actually an employee and therefore was not entitled to a statement of terms of employment in accordance with the Terms of Employment Information Act 1994. The adjudication officer, in his deliberation, looked at a UK case, and the UK case set out a number of tests. Those tests were 5 questions. 1, does the person performing the service supply his own equipment? 2, can he hire his own helpers? 3, does he carry any financial risks, and to what extent? 4, what opportunity does he have to make a profit? 5, to what extent does he carry the responsibility for investment or management? So there are 5 questions that the UK case to which the adjudication officer referred looked at in order to decide whether a person was an employee or an independent contractor. The adjudication officer also looked at the Revenue Commissioner guidelines here in Ireland, and on that basis there's a number of questions that the Revenue Commissioners will use to determine self-employment or otherwise. 1, is he under the control of another person who directs as to how, when and where the work is to be carried out? 2, does he receive a fixed wage? 3, does he supply labour only? 4, can he subcontract the work or not? 5, does he supply his own materials for the work? 6, does he provide his own equipment other than small tools of the trade? 7, is he exposed to personal financial risk in carrying out the work? 8, does he work set hours or a given number of hours? So the adjudication officer, on the basis of those questions, decided that in this instance, this case, the doctor was in fact an employee, notwithstanding the fact that he had his own GP practice away from the contract which was the subject matter of this claim. So clearly a person can be self-employed and have an employment contract in addition to that. And the doctor won the case. Now the claim was to get a statement of employment, a statement of certain terms and conditions of employment. The penalty for failure to deliver such a statement is relatively small, it's 4 weeks' wages. In this case, the adjudication officer decided that even though he was entitled to a statement of employment, even though he was held to be an employee, that the particular circumstances of this case ensured that he did not consider it just and reasonable to make any order for compensation retrospectively. So there was no award for compensation in respect of the failure to give the written contract. I don't know whether this case is being appealed to the Labour Court or not. It on its own is a relatively minor case. However, there is, I think, a number of other cases riding on it, or similar cases that are going to follow on. So it's important, probably from the perspective of the respondent, that the precedent or the decision is not accepted, and it may well be appealed. No, I don't know whether it is or not, but that's the position. This decision was issued on the 18th of December 2019, and it's a good decision to look at in looking at the question of self-employment, independent contractor versus employee. I've written a blog post about it on my website, employmentrightsireland.com. You can have a look at it there. It looks at the situation, looks at the case in a little bit more detail, but more importantly, there's a link at the end of that blog post which links directly to the actual decision of the adjudication officer in the Workplace Relations Commission. It's worth having a look at if you are interested in this sort of thing, and if the question of employee or self-employed is something that concerns you. I hope you find this video useful. If you do, give it a thumbs up down below, and you might consider subscribing to my YouTube channel. If you do, just hit the bell icon down below and you'll be notified every time I make a new video. I make a new video at least once a week. Thanks for watching.